And your rule also does say, as Allison alluded to, that if there are aggravating or mitigating factors that aren't on this, the director can prepare a summary of those factors for the commission to consider, and it doesn't, and this method doesn't limit the commission's authority to exercise its discretion to deviate from the calculated sanctions from Table B and modify the civil penalty or forfeiture.
Thank you very much. So what that means, everybody, is that we have 22 violations that could potentially, that the upper limit is $5,000 per violation. There's also there is also the forfeiture. If we find that someone profited by a violation with a known amount, then the law allows us, say there was a contract for $100,000, and if that contract violated, or if the actions there violated one of our statutes, law allows us to claw back that profit up to twice the amount. Is that correct?
Yes.
So that would be a $200,000 fine, but as our attorney has just cautioned, that the case law makes it very clear, and it was in Marie's handout when she analyzed several of the cases, that unless the precise amount is known of what was ill-gotten, although the violation will stand, the penalty will not. So that's at least.
For the forfeiture would not.
For the forfeiture. That is, if you go above the 5,000, that's what the case law says. Is that correct?
Yes.
Okay.
So the recommendation is to stay away from the forfeiture because we don't know the dollar amount?
Well, I think we should discuss that, but I just wanted to let everyone know what the contours are.
Do we know any of the contract amounts at all, or do we just not know any of them?
I think you have copies of the contracts.
We know the amounts of the contracts, we don't necessarily know what she would have gotten without these contracts.
Right, I mean, I know that we have the contracts here, but maybe some of them had like, you know, retainer fee per month and plus hourly fee, and if we didn't know what the hourly fee was, or how many hours were charged, then we wouldn't have a precise amount, that kind of thing.
Right, and I think that's definitely true for the Energy Foundation contract, because it's $50,000, it includes travel expenses, and so there's no way of differentiating what was pay and what was travel. That was differentiated in the Resource Media contract.
Because it sounds to me like legally, if the amount was even like $10 off, it wouldn't be precise and we wouldn't be able to enforce it.
I'm not sure, that'd be a question for legal counsel. There's only one case cited.
Yeah.
It's possible a court might find that's close enough.
Mm-hmm.
I also think there's an evidentiary question, you know, whether she would have gotten any of this contract. Maybe she would have without doing the things in the office. Mm-hmm. There's an evidentiary question there, which is not easy to answer for the forfeiture provision.
I think it's possible, I'm sorry, I haven't been recognized. I think it's possible that we may be able to send the signal necessary to execute our mission as OGEC without necessarily doing the forfeiture based upon the penalty per violation.
Commissioner Sosa?
I mean, even without the forfeiture, with 22 violations, if my crude math is good, it's $110,000 is what we potentially could levy against her for this. I mean, if we're airing our thoughts on that, I think that what we have here is a blatant disregard for the ethics laws of this state that was recognized early in the administration. It was raised with her in September of 2011, and she pushed back and said, well, that means I would have to forego all of my consulting or policy involvement with the administration. So she knew in September of 2011 that this was going to be an ethical problem. You also have Governor Kitzhaber, who is acknowledging early on that he is going to be reaching out to the Government Ethics Commission. This is in June of 2011. He sends an email that says, I'm getting a list of possible questions for the Ethics Commission to give us clarity one way or the other. Mostly, I think we need a clear plan forward. That was never done. So we have in June of 11 and we have in September of 2011 this issue being raised, and there was in my opinion, a purposeful refusal to engage with the Oregon Government Ethics Commission because they probably didn't want to know what the answer was going to be. And so only later, when they're forced to do it, we don't even have an attempt to comply, realistically, until 2013, and no approach to the Ethics Commission until 2014. As we've discussed at length here today, I think that this is a case study in what you are not supposed to do as a public official. And I think that for that reason, the statute gives us the authority to levy significant fines for this extent of violations, and I think that's exactly what we should do.
Other comments? Commissioner Fiscal?
Madam Chair, I agree with Mr. Sosa, almost word for word, Nathan. I think the gravity of the circumstance that is well outlined in the 150-plus page report by our staff underscores the need for the maximum penalty allowable under law, whatever that is. If it's 110,000, that's where I am, rather than some variant on that or some lower payment in light of the gravity of this circumstance. So as a signal from one commissioner, that's where I am. The maximum fine penalty allowable under the law. And I will leave the forfeiture issue aside for the moment because that's too complicated for me to even understand the details of it, with all due respect to our counsel. So I think the $110,000 is where I would be. 5,000 per violation. Thank you, Madam Chair.
Thank you.
Could I ask staff for between now and next meeting, just to put together some rough numbers of what documentation they have on, like, what the financial benefit for a potential forfeiture? Where, you know, obviously, based on, you know, our previous discussion, that looks like a challenging aspect, but I would think that we would want that to include that. Or at least to be able to look at that. And obviously, if, you know, we have a number that's documented through contracts or whichever it is.
So I have numbers now, but I don't have numbers, as Amy was saying, regarding what she would have to show, what Amy would have to show at a contested case hearing in terms of the forfeiture.
What would be the total number then?
Well, I haven't done the math yet, but it's somewhere between $110,000 and $123,000 for the Clean Economy Acceleration Fellowship, $45,111 for the Resource Media contract, $50,000 for the Energy Foundation contract, and $25,000 for the DEMOS contract. So I can do some math here if you want me to, or someone who's been writing
Sounds
that
like
down.
about 400,000 as a rough.
Maybe
Did I hear it out?
250,000. My rough estimate, I can do the math, but it's
Okay.
250-ish.
Oh, only 250, okay, I thought it was, and then there's the doubling that's allowed under state law.
The civil forfeiture can go up to double.
Can double. Well, so maybe for the next time, following up on that, we could have just a breakdown of what the possible costs are, and when we talk about civil forfeiture, Amy, maybe you could just do a little blurb about what we have to know in order to find that, which I think what you just said was, we would have to know that a certain contract in which 30 speeches were paid for, and we know that maybe there were a couple that didn't involve her position, that we couldn't prove she got, but for her position, it might make it difficult to come up with a precise amount of what she was paid for the other speeches, because it sounds like I'm not sure what all the speeches were.
Yeah, nothing is laid out in terms of which hours did she spend doing what, and how much were those hours worth. It's
Okay.
all lump sum payments.
Okay, well, maybe at the next, we're not meeting again to approve numbers until and unless you come back with a settlement amount. Correct?
Yes, Madam Chair, so from what I've heard is that, what I'm hearing is that the commission's really not interested in settling at this time. So, as we're talking about the maximum penalty, nobody settles for the maximum penalty.
Well, I don't think.
Nobody settles for, twice the amount of forfeiture, so, I think what we'll do, we'll inform Ms. Hayes of the commission's action today of finding the violations. And then we will, see if that's appealed. If it is appealed, then we will go from there. But we can't come back at the next meeting and talk to you about that.
And if it's not appealed, then it comes back to us for finding of sanctions?
It comes back to you for a final order.
That would
After
include-
it's gone to a contested case, so.
Well,
the
no,
notice-
if they don't appeal,
If they don't.
if they don't
They don't
appeal, it
Yes,
comes
if
back
she
to
doesn't
commission
ask for a contested
for a
case.
final order that the commission then would include the sanctions entirely.
Okay, Commissioner Burke?
Yeah, I don't have the same understanding of this conversation that I think the executive director has. My understanding is that we were talking about maximums that we're automatically going to advocate for imposing the maximum penalty, but that we're trying to get a grasp on what the ranges are that we have to deal with.
I don't think that's what your Commissioner Fisco had said.
Yeah.
Yeah, I didn't hear that from Nathan, so.
And I might be, oops, stop that. No, I might be wrong about that, and if so, I apologize. I think what we need to do here is, I think this merits far more than a slap on the wrist. I think we need to find out what would be a penalty that would be consistent with following the mission of this commission. But I think that we should leave enough room for there to be a settlement. But I would not be in support of any settlement which would be perceived as a slap on the wrist. This isn't a trivial situation. These violations are not trivial. But I'm not understanding that we are all, at this point, focusing around imposing the maximum penalty in every permutation.
Any other comments? Oh, Commissioner Sugar.
Thank you. I generally would say I agree with Commissioner Burke on this, and I think, the value of our discussion is that it allows us to explore the parameters of our authority, and also get a sense of where this could go. I agree that we should keep the possibility of settlement open for future discussion. I know that it's traditionally the strategy of the director to reach out and offer settlement, possible settlement negotiations to someone, but perhaps this is a situation where it comes the other way.
Mhm.
And having heard our discussion this morning, there's some understanding of culpability and an effort to reach out in an offer of settlement coming from Ms. Hayes instead. So I just think it's important to keep that line of communication open. It doesn't mean that we've committed to anything. I also, I have to agree with the concerns raised by all the other commissioners regarding the conduct and the breadth and depth of what we've learned. So that's all that I have.
Thank you. Yeah?
I think if you're gonna negotiate, you don't go in small. And that's where, I think that Commissioner Sosa brought up some great points on a high dollar amount. And I think at this point, and this is probably a generational case, I mean, this is gonna last a long time, and I don't think it benefits the commission to go small, early on when there's no reason, to do that. So I would
agree.
keep that.
I don't want you to perceive me advocating going in small. I just wanted to throw out there the concept that we would leave room open for some kind of negotiation, but I agree,
sure.
you don't go in small.
Commissioner Fisco?
Madam Chair, my comment about heading toward the maximum was informed by our experience with the previous issues separately considered relative to former Governor John Kitzhaber. And when we turned down that stipulated order, my own view for turning it down was in part because it came across to me as too lenient in light of the reality of even that circumstance of 4 violations to which the former governor admitted. There's always room for settlement. Maybe the other side could settle for the maximum in light of the possibility of even going beyond that in the spirit of our conversations about forfeiture. But I think the gravity of this circumstance in the blight on Oregon's reputation for clean government is so serious that we have to take it very seriously. And for me, that means heading toward the maximum. And we're trying to give our staff guidance, which I think they deserve, as opposed to giving them an order, until my comment is guidance, not an order.
Commissioner Schiffer?
Chair, I have a question for council and potentially for staff. And, just to clarify procedurally, although the commission voted, for the preliminary, findings, heading into potentially a contested case hearing if it's appealed, is it still a possibility that, in advance of the actual litigation at an administrative hearing, the complaint or whatever you call your pleading, could be noticed, I suppose, could be amended or even expanded if necessary, if additional violations come to light?
Yes, the notice can be amended, but the investigation period has ended or will end.
It'll end on the 10th.
And anything that is associated after that, you can't come back in and amend it.
When Amy takes this over from me to look at it for a contested case hearing, I don't know that we can, I don't think the commission can consider additional preliminary findings of violation, so it would be hard to add them. Amy may find additional evidence in what I have that I didn't see, or she may have better search engines or something over there at DOJ, and be able to find things that I couldn't find here, and she could use those because we already have them in our documentation here. But I don't think she could add violations.
No, and also nor could the ALJ do that. So, I mean, you could amend it, you do amend notices frequently, but not, because of the commission's investigative period, statutory investigative period, you kind of foreclosed once you get beyond that from.
Even if there's newly discovered evidence?
Well, if there's there's nothing that specifically says that in your statute. I don't think we've ever dealt with that before. Have you ever dealt with that before, if the commission's made preliminary findings?
My understanding is there'd have to be a complaint filed on the new evidence.
But we're outside of the statutory.
And we would go back.
You can
to the
only go
same
back 4
procedures
years.
Yeah.
and review an investigation.
All right, thanks for the clarification.
Any further discussion on